Good morning. It is Monday, July 21st, and I know it's been a while. I've been out, but I'm back, and a lot of things have happened in the past few weeks that I want to address, and I will address. But perhaps the most important thing and the most urgent, I believe, is the new ICE memo declaring any undocumented immigrant detained by ICE ineligible for bond. What this means is that their argument is that an immigration judge cannot issue a bond for anyone who is undocumented in the U.S. and detained by ICE and placed in removal proceedings. So let's get into this, and I want to explain this a little bit more, what's going on, and kind of my thoughts on this. First, the law says that any immigrant arriving at a port of entry is an arriving alien, and this is someone who comes to the U.S., like I said, at a port of entry through an airport, or perhaps is detained at sea and then brought to the U.S., and that these arriving aliens are not eligible for bond and are subject to mandatory detention. This has been law for a long time. This is not anything new. So this is not a new legal theory. Okay. And this has led to thousands of people in ICE custody subject to mandatory detention. So, this isn't new. The new part is the fact that now applicants for admission and the interpretation of who that is are also completely ineligible for bond. Now, an applicant for admission can be somebody who arrives at the U.S. either at a port of entry or between ports of entry, right? Land crossing. Or also someone who is present in the U.S., physically present in the U.S., but, U.S. immigration authorities haven't given them permission to be here. Now, the new change in ICE policy is the argument that regardless of how long they have been in the U.S. after entering, if somebody entered without inspection, whether or not they were arrested immediately after their entry or 20 years later, they are still an applicant for admission, and therefore they are not eligible to ask an immigration judge for release from detention or bond. This means that even though, again, they've been here for many years, because they were technically never given permission to be here in the first place, they're still asking for permission to enter. That's their argument. And as such, they're not eligible for bond. Now, this goes against, previous ICE policy and what we as attorneys have known to be true. In other words, most immigrants who entered the country without inspection but have been here for a long time typically were eligible to ask the immigration judge for a bond. And usually the immigration judge would decide whether or not they were eligible for a bond based on whether or not they were considered a danger to the community or a flight risk, right? Making sure they believed that they were going to show up to their immigration proceedings. So basically expanding applicants for admission to essentially apply to anybody who's been here, who entered without inspection and is now here undocumented, allows them to hold individuals and say that they are subject to mandatory detention. That's the ICE argument. Now, what should you do? You should still seek bond with an immigration judge. This is the ICE attorney's argument and interpretation of the law, but there are still some judges who might not agree with it. And so, it makes it a little bit difficult because ICE attorneys and EOIR judges report to the same boss. This is where that judicial branch and having having immigration judges as part of the judicial branch becomes so critical, because right now they're part of the executive. This is an administrative court, and the ICE attorneys and the immigration judges report to the same boss. And therefore, they also have their directives from this administration. But like I said, there are still some judges out there who are willing to be objective. And even if you lose, you can still try to appeal up to the BIA and to, a circuit court who might be more objective because they are part of the judiciary.